Hello, everyone. Bonjour, bienvenue. I'm Sean Rehag. I'm the director of the Center for Refugee Studies, the director of the Refugee Law Laboratory, and an associate professor at Osgoode Hall Law School. I'm delighted to welcome you all to today's joint seminar hosted by the Center for Refugee Studies and the Refugee Law Laboratory. The seminar, as you know, deals with the question of open courts and privacy in the specific context of immigration and refugee law. There is a discussion paper that the Refugee Law Laboratory has put together for this event, and I will post a link to that in the chat in just a second. What we're going to do today is that the co-authors of that paper, that's me and Jonathan Can, will speak for about 15 minutes each about some of the themes in that paper. Then we're going to have 5 discussants who are going to articulate their views about open courts and the privacy principle. Then we're going to stop the recording and we're going to have a Q&A session so that we can take some questions from the audience. In the Q&A session, it should be understood that nothing said during that session is for attribution unless the person speaking gives permission for that, and that no one is speaking on behalf of institutions unless they make it clear that they are doing so. Okay, so with all of that in mind, I'm going to introduce our first speaker, who is John Can. John is a doctoral student at Osgoode Hall Law School. He's also a researcher at the Refugee Law Laboratory. Before pursuing his doctoral studies, he was legal counsel at the Department of Justice. He's also served as a law clerk in BC's Supreme Court. John's research focuses on deliberative design in Canada's legal system in order to improve the efficiency of the system and in order to enhance access to justice. One of the key themes in his work is that Canada currently suffers from a legal data deficit. And what he's trying to do is to build and analyze data sets about judicial decision-making in order to develop strategies and tools to improve access to judicial decision-making and decision writing. And so his research comes up directly against some of the challenges that we're going to be talking about today. That is, in an era of increasing interest in legal analytics, in access to legal information, in bulk access to decisions and other court materials, there are concerns that arise in relation to privacy. How should courts try to address those concerns? That's what we're going to be hearing about from John. So, John, over to you.
Thanks for that kind introduction, Sean. So I'll just briefly lay out kind of the introduction to the paper and then proceed through the first 4 parts of it. So as Sean mentioned, one of the things I think that is starting to be talked about more now, but historically has not been talked about a lot, is Canada's failure to really appreciate, and when I say Canada there, I'm speaking across the board of all courts, how little data there is on the legal system. And in the words of many folks, you can't fix what you don't measure. And many times you can't even identify a problem if you're not measuring it. So over the years, Canada has taken many steps to start to address some of the data deficit, and court decisions and some court documents are becoming easier to access, including online and electronic formats. And this increased democratic access, as I'm sure you're probably going to hear from Sean and Colin, does provide many benefits, but one that doesn't get talked about as much and really is the focus of a key theme in our paper, is the ability for increased access to legal documents, decisions, and legal data generally to provide increased fairness for litigants in the process. But to state the obvious, many of those documents contain intensely personal information, and public exposure of it, especially in the immigration and refugee context, can lead to harm and at times even physical harm. So far, governments have largely left courts on their own, and likely for reasons of judicial independence, to resolve both access considerations and privacy considerations. And unfortunately, as Anne's work has demonstrated, this has led to a bit of an unequal, inequitable access regime across the country. The ability to access documents in the federal court is quite different, for example, from the most Western province in British Columbia. In contrast to quite a few courts, the Federal Court of Canada has recognized these issues in its most strategic plan, and also historically, in terms of measure it's taken over the last two strategic plans. And it's really seeking to grapple with these 2 points of access and privacy, but also all of the ways in which legal documents, legal data, and judicial decisions can really increase the ability of the federal court to do its work in efficient, just, and fair ways. One of the things that the federal court has been doing is consulting with stakeholders on this issue. And Sean and I wrote this paper to try to participate in that consultation with a particular focus on immigration and refugee decisions. And to date, the consultations have really highlighted that immigration and refugee decisions do raise issues of particular concern, but it's also highlighted some views that are a bit concerning from the perspective of calls for restricted access that we believe could compromise the open court principle and overall systemic fairness. So in the article, we suggest that the federal court can both enhance privacy interests, thinking about both historical data and go forward data in immigration and refugee proceedings without compromising the open court principle. Any measures that are taken by the federal court or stakeholders or lawyers who are working in this space to protect privacy must really avoid amplifying existing unfairness that already exists in access to legal materials. And we say that the federal court should really avoid creating access regimes that asymmetrically block research and technological development that could enhance the interests of refugees, other displaced people, and people on the move. So with that context, I'll briefly turn to part one of the paper, which addresses the federal court's strategic plan, which was released in 2020. And one theme from that report was quite clear, and that I think theme has been proliferated across many courts, which is COVID-19 has really stimulated the court to rapidly innovate. And the court is quite clear that it is accelerating its shift away from being paper-based toward being a more accessible digital court. And that obviously raises huge access to justice benefits and efficiency benefits. But the court is obviously concerned about privacy. So it's not rushing into the shift, and it appears to be doing it in a graduated stage by stage, with immigration and refugee proceedings being one that is kind of being left into the future a little bit as things are figured out in terms of access and privacy considerations. But to date, consultation has really reviewed some surprising divergent views on privacy and access to documents. At one end of the consultation spectrum, the CBA has effectively called for a reverse onus approach to accessing many court records, both electronically and in person. And it argues that this approach is necessary because the previous practical obscurity of paper-based records offers a form of privacy protection that won't exist online. And for context, practical obscurity is basically the idea that if documents or data are hard to access, which is often the case for print documents, they are more private. At the other end of the spectrum, the Canadian Media Lawyers Association strongly objected to the CBA's proposal and argued it would frustrate transparency. It went as far as saying and cautioning the court to be wary of fear-mongering about how technologies might be used as an excuse to place limits on the open court principle. We disagree with both ends of the spectrum. In our view, the CBA too easily sacrifices the open court principle in the name of privacy, And the Canadian Media Lawyers Association fails to recognize and accommodate the very significant privacy interests at play in the immigration and refugee setting. Even worse, though, and this is a key theme in our paper that appears to be absent from some of the Canadian literature, likely because the issue of big data in the Canadian context is only really emerging. But it's this, that traditionally fair and equitable approach to court materials has not really materialized in the context of immigration proceedings, where there are overwhelming power imbalances between the government and litigants, as well as incredible information asymmetries between what's accessible to lawyers representing claimants versus lawyers representing the government. And I'm sure Sean will unpack that point in more detail. Turning into part 2 of the paper, and really, I think this point and this section is really necessary to kind of ground our thinking in where we're at in 2021 with open courts. And despite the points that I noted at the outset about Canada's legal data deficit, as well as the points that Sean noted, Canadian judges in courts in 2021 are historically far more transparent than their historical colleagues. For example, for most of the common law's history, judges didn't issue reasoned decisions explaining why they decided as they did. Now that's pretty standard in most proceedings, or there's an audio recording if written reasons aren't offered, with the one important exception of many immigration and refugee decisions where reason giving is not part of the standard course. All the more reason to have robust access to the underlying and related court files to really make sure that the way the system is supposed to be working from a fairness perspective and an efficiency perspective is actually provided. And we often hear about open access relationship to democracy and accountability and all of the various things that are invoked in this context. But what Sean and I are advocating for in this paper is to look at it from a third lens, and that really is the lens of fairness and technology, and how technology provides the ability both to audit what's going on in the system, but also to have different tools that are available to individuals as well as stakeholders in the system to improve the ways that individuals are going about making submissions, advocacy, etc. Yet many individuals are quite skeptical of technology. And also note in a moment, there's almost a technologically deterministic idea baked in where individuals seem to be calling for more status quo style protections. And Anne's work in her LLM thesis at the University of Toronto really highlighted that the status quo of many regimes is actually not what a lot of individuals think it is. In some ways, it's ironically privacy intrusive in that you can go into a courtroom, you can anonymously observe what occurs, you can hear incredible viva voce evidence that contains a lot of personal information. But if you want to access that information outside of the courtroom, you often have to justify why you want to do it through an administrative process and provide your name and contact information, which obviously flips the onus in a direction that the Dagenet-Mentuk framework does not really truly contemplate. And as I noted earlier, the CBA is calling for that style of approach to be baked into the federal court's access process, both for electronic documents as well as paper-based process. And that would be a regression to the federal court's typical regime, or how it currently works in the federal court, where the federal court stands out as one of the few Canadian courts that does not require an administrative process to actually view court files. In our view, no new technology or technological risk should justify relying on an antiquated approach such as practical obscurity or a dated approach to thinking about privacy. Rather, the technological revolution that courts are finally starting to participate in really should not reduce transparency, it should increase it. It also should not reduce privacy, it should also increase it. And so what I'm going to talk about in the remaining time I have left is just really that the technological revolution should encourage us to revisit both what's required for adequate transparency, but also what's required for adequate protection. Turning very briefly to part 3 of the paper, and that is kind of what the status quo regime is about now, and this idea of practical obscurity that I've mentioned quite a few times. And in our view, practical obscurity was never a great solution for protecting privacy. It effectively relies on people being lazy, people lacking time, or lacking money and knowledge about how to access court records. We believe more upstream solutions could achieve the goals of both privacy and access without minimal compromise to privacy or open courts. For example, technology could improve our ability to understand what information is actually necessary for the court file and what's actually extraneous and not necessary. I think many lawyers and judges would agree that a lot of stuff that ends up in the court file is often not relied on or not used, and yet it contains an incredible amount of private information. So one of the things we discuss in the paper is the ability, if, for example, court records were structured better and judgments were structured better, and I'm sure Colin could speak to this, to have auto tagging and auto redacting done of documents to actually figure out the information chain of information as it proceeds through the court system. But 2 quick points on practical obscurity. We raised 6 in the paper about why the solution seems to be a bit of a flawed method to actually protect privacy, but 2 are really key to me. First, practical obscurity and these practical friction ideas really do promote inequitable, uneven access. So Westlaw and Quick Law, for example, have the ability to access large amounts of legal information, and they've built up an incredible monopoly, whereas the average researcher, such as myself or Sean, simply doesn't have that access. But it also spills out to folks with less money, or as David Leposki discusses in his work, individuals who simply can't access legal information in the traditional ways, such as going to a courthouse because of some type of disability that may preclude them from doing so. The second main flaw of practical obscurity is it doesn't actually promise to keep private information private. It just promises individuals the expectation that their data will remain obscure. In other words, it's not actually a targeted or tailored privacy solution that is built or designed to actually maintain privacy. It's really just a blunt tool that relies on inefficiency to protect some of the most personal and sensitive details of individuals' lives. I think we can do a lot better in 2021. So briefly just turning then to part 4 of the paper as I wrap up and discuss the various technological opportunities and challenges of improving privacy in open courts. And then Sean, I think we'll talk about how this works in practicality, or could work in practicality, in terms of the current problems and the asymmetries and imbalances that currently exist. So one of the things that I think is really fundamental in this conversation is the idea of privacy being pitted or balanced against accountability. And really, this pitting or this putting side by side creates a bit of a false binary where privacy is pitted against openness. And these framings, as I alluded to earlier, suggest that technology is somehow inherently privacy invading, rather than technology potentially being a tool for privacy promotion. So one of the things that's really crucial in these conversations is shedding the technologically deterministic binary of technology bad, privacy can't coexist with technology. Instead, humans and the agents that are in this space have the ability to wield and use technology as a tool to both promote privacy and openness. And other disciplines have considered many of the same issues that law is considering. One that I pull on quite frequently in my research are medical records and medical record keeping systems. Often the end users of those systems, doctors, patients, are completely ignored in the design of the records. And that might be true as well for judicial decisions and records, where individuals might be including more information because they don't actually understand what's supposed to be in the court file. So efforts have been made to improve medical records, including design challenges, where individuals are thinking about what are the upstream things that we can actually start including in medical records, or maybe not including in records, so that the later research processes are more efficient, fair, but also privacy promoting from the perspective of, if privacy is built in at the outset, then privacy is not something that we have to consider as an afterthought. Redesigning the court record is likely outside the scope of the federal court strategic plan right now, but it's something that certainly should be thought about by all courts in terms of what are the ways in which the court record could work better from a litigation perspective, from an information management perspective, but also from a research perspective. Either way, one of the things that is imperative to us, and we stress this point in the paper, is that the court really needs to ensure that the conversation doesn't ignore technological possibilities. So for example, a pilot was run, but in principles of deliberate design or system design, one pilot would be the beginning of many iterative pilots. So one of the things we talk about in the paper is, instead of hypothesizing about worst case outcomes, the court, for example, could work with technological stakeholders to identify modern threats to privacy, modern privacy controls, lifecycle protections, such as the ones we point out in the paper from Altman et al. And then the court could actually try to, for example, avail some modern anonymization techniques, which I'm sure Colin could speak about, replicate previous identification or re-identification efforts that is quite rich in the United States of, is data actually ever de-identified? Put another way, it could do what tech experts call red teaming, where system designers effectively try to break or invade the security or privacy mechanism they created. So instead of worrying about privacy controls or worrying about privacy threats, one of the things we really call for is to try to actually envision what is the targeted problem that the court is concerned about or a stakeholder is concerned about, build a solution to address that problem, and then try to break that solution from the perspective of what are the ways in which it may fail, and then build another prototype and continue to iterate in this space, rather than a one and done solution to this is how we're going to approach privacy because of technological limitations or because of technological fears. So with that, I think it will be a good point to move to Sean and hear a little bit more about how the information asymmetry as well as the current power imbalances really could be further proliferated by reliance on technology. And that's a prime concern for both of us. Thanks for listening to my thoughts on the paper.
Thank you very much, John. So as John mentioned, what I'm going to speak about is how this is all playing out specifically in the immigration and refugee law context, and then I'll summarize some of our recommendations in this area. So the starting point for a discussion about open courts and privacy in the immigration and refugee law context is really to understand the seriousness of the privacy interests that are engaged here. And it's important to be specific. And so when we think of what is contained in court decisions and what is contained in court materials in the immigration and refugee context, we need to be thinking about things like the way that court decisions might disclose the sexual orientation of a refugee claimant who's facing persecution on account of their sexual orientation. It might disclose information about intimate partner violence or sexual violence. It may disclose information about a person's political opinions or their religious views. It may disclose information about stigmatized mental health conditions or other health conditions. And so there's very private information that is at play, and that's just in the decisions. If we start to look in more detail at what's in court records, we see things like identity documents that could facilitate identity theft. We see information about where people live. We see information about third parties. So you can imagine, for example, someone making a refugee claim based on being a political dissident in an oppressive regime. They still have family members back home. Those family members may be identified by name, and as a result of that information being publicly available, the third parties might be targeted, might be persecuted, might be tortured, might be killed. So the privacy interests here are at the very high end of information that is sensitive and that needs to be protected. So I think that's the starting point for this discussion. Another starting point for this discussion is that the status quo is not privacy protecting. So I mentioned all the information about sexual orientation, political views, intimate partner violence, all of that stuff is currently available in online decisions where parties are named. And anyone can go on and grab that information. It's possible to get that information in bulk. It's a little bit difficult, but it's possible to do it. So the status quo is not privacy protecting, and it has the potential to get worse. It has the potential to get worse if more parts of the court record are publicly available. It also has the potential to get worse because of technological developments. It is increasingly common for researchers like me to try to get bulk access to these materials. I expect that there are nefarious actors who are collecting a bulk access to this material. I expect that there are lots of commercial actors who don't have nefarious intentions, but who are collecting this information, which could be used in lots of different ways. And so the status quo is not privacy protecting. Something needs to be done about it. Things could get worse in this area. So that's the first point. The second point is that this is an area where transparency really matters. It really matters because immigration and refugee law is an area of law with extreme power imbalances. You have the government that's dealing with a group of people who are made marginalized because of a variety of intersecting factors, immigration status, obviously, but race, class, disability, and gender, and so on. And so you've got a powerful government with limitless resources, or almost limitless resources, dealing with a marginalized group. In addition, you have other structural inequality. So the government sets the rules. The government sets the procedural structures for oversight of decision-making in this area. The government creates the courts. The government sets the rules of the courts. The government names the judges. The government decides which judges are promoted. And the federal court has done all sorts of work to try to create fairness in that context of severe power imbalances. But the power imbalances mean that it's particularly important to have transparency in this area. It's particularly important that the media be able to look into problematic decision-making in this area. It's particularly important that researchers like me are able to do studies of decision-making in this area to propose ways of improving decision-making. So transparency matters. The status quo does not provide transparency. It's very difficult to do research on certain forms of decision-making in this area. If you want to understand why are the majority of what's going on in the majority of cases in the immigration and refugee law area where leave is denied, you want to understand decision-making, it's very difficult. You actually have to go to the court, obtain paper records, look at those paper records. It's not a very transparent process. So the status quo is not transparency enhancing. Finally, there is a third element here, and that's the element that John identified, which is the question of fairness. One of the power imbalances in the immigration and refugee law setting is informational asymmetry. The informational asymmetry is caused by the fact that the government has access to all of the record, all of the documents, all of the decisions in every single case because they're a party to all immigration and refugee law decision-making. The same is not true for individual lawyers or individual parties on the other side. So you have one side that has access to everything, and the other side needs to access things through the court. You have an informational asymmetry that is problematic. And the government has leveraged that informational asymmetry in the past. And so I'll give you an example. There was a series of critiques from the private bar over several years about the way that the Department of Justice was using information that it had about stay decisions in other stay in litigation involving stays of removal. And the issue was that the government had the decisions for every stay decision, but that those decisions were not published. And so DOJ was coming to the court and saying, look, here are 5 cases that where other judges have denied stays in similar circumstances. And in the meantime, lawyers for applicants who were seeking stays of removal weren't able to do the same thing. They weren't able to look through all of the stay applications. The federal court, this is an example of the federal court, I think, effectively responding to the power imbalances. They have recently decided to make the stay decisions publicly available on CanLII in order to address the information asymmetry and the unfairness that's caused if only the lawyers for one side have full access to the law and lawyers for the other side don't. So that's one specific example that I wanted you to think about how the government might leverage information asymmetry. I want you to think about a second example as well, and Colin might like this particular example. So I was a law student at McGill in the late 1990s, and I think I was one of the last years where they still taught law students how to manually note up cases in kind of dusty old books. And so we went off, we looked at paper court reporters, we found decisions. We wanted to know, have these decisions been dealt with in subsequent cases? We looked up how do you shepherdize in an index? How do you note up in an index? And when I asked, why are we doing this? This is available on Quick Law. I can just go onto my laptop and the answer was, well, not everyone is going to have access to Quick Law. And at the time, the government had access to Quick Law. People with deep pockets had access to Quick Law. Refugee lawyers did not. And if you're on refugee lawyers listservs, as I am, you actually still see to this day lawyers sending out emails saying, hey, do you have access to that case that was published in the early 90s on Quick Law or on Westlaw? Because I don't have access to Quick Law. And so that context there, where you have parties with that represent institutions or people with deep pockets, get access to services like Quick Law and can access all of the documents effectively in order to make their legal arguments, whereas the other side is working through an inefficient, ineffective, old paper-based process. My argument to you is that we are about to encounter something very similar in the era of computational law. Now, we have, for the most part, resolved this specific problem by investing in organizations like CANLI. So CANLI has, to a fairly significant extent, evened the playing field in this era. But as we move to an era of computational law, where it's not just, can I do a quick Boolean search to find a specific case and read the case, but where it's working with legal analytics to make predictions about outcomes, where it's working with advanced technologies that are going to help you figure out really what are the key cases, where you're working with tools that are going to help you write your pleadings. Those tools are in some areas of law are here. If you work in tax law, for example, and you are a customer of Blue Jay Legal, you can do some pretty cool stuff. But that technology is coming in other areas. The government is already trying to leverage its own access to materials to create those technologies. DOJ is working to try to build some of these technologies. At the moment, I understand that they're doing so using published decisions. But as we move to a greater number of electronic documents that are going to be put in put into the court file and that are now going to be available to the government in electronic format, they're going to leverage those materials as well. And so in that context, where we've got, where we're moving towards this era of computational law, we need to be careful that we're not making decisions that amplify the power imbalances and that amplify the information asymmetries and that lead back to the days pre-CANLI, where lawyers for institutions and lawyers for people with deep pockets get access to technology that's built off of access to legal information, and lawyers for marginalized people don't. That's just not an acceptable outcome. It's not a fair outcome. And so what do we do here? I think what we do is that we look for solutions. We acknowledge that the status quo in terms of privacy protection, in terms of transparency, and in terms of fairness, the status quo is not acceptable. So we need to look for solutions that can help us maximize privacy, maximize transparency, and maximize fairness. When we think of maximizing fairness, it's addressing informational asymmetries, but it's also thinking about people who can't access materials in paper form. And I think David might have something to say about that question. So we need to think about equitable access. So what does that mean? Well, you can see on pages 36 and 37 of the discussion paper that we've circulated. You can find a link in the chat. Those of you who registered a few days in advance, I've also received this by email, so you can see the full list of suggestions, but some of them include anonymizing court decisions on a going forward a basis. They include thinking carefully about what makes its way into the court record to begin with. That includes having some changes in the way that lawyers do their work, but also some changes in the way that the Immigration and Refugee Board, IRCC, CBSA put together materials that end up in court records. We need to think about using technology to do automated redactions, which is something that I know Colin has been working on. So there are some possibilities here that we think would improve privacy, that we think would maintain transparency, and that we think that it could actually help address the information asymmetries and provide more equitable access. The key in all of this, I think, is to pay attention to all three of those questions. So far, the consultation materials, I think, do a fairly good job of highlighting the privacy concerns and highlighting the need for transparency. I think what's missing really is the question of equitable access in a context of information asymmetries. So that's what our discussion paper tries to argue. And now what we'll do is we'll hear from several discussants before opening things up to a Q&A. So our first discussant is Amy Salazin, who's a professor at the University of Ottawa's Faculty of Common Law. Her research focuses on legal ethics, gender in the law and technology, and civil justice reform. Those research interests make Amy no stranger to the topic that we are discussing today. Most recently, Amy, along with a colleague, Jenna McGill, published an article considering the future of Canadian judicial analytics, including upsides, downsides, and potential responses. I encourage you to take a look at that paper. It's a great paper. So Amy, over to you.
Thanks so much. I'm so delighted to be welcomed here today. As I told the hosts, I'm having lately some challenges with my Wi-Fi, like many of us do from time to time. So please let me know in the chat if I cut out. Sean and John, I assume now I'm sounding okay? Okay. It's always the worst when you think you're sounding okay and everybody else is not hearing you. I really enjoyed reading this paper. I wanted to say that first. I could probably spend my full 7 minutes giving compliments, but maybe I'll just give a few. The approach in terms of trying to take a balance between, not simply going for unfettered access and then not simply going for, full privacy, and thinking about this balance, I thought, was really refreshing and thoughtful and ambitious. I did also really like the precision with which you talked about some of the context and concerns. So the fact that there's some concerns related to whether or not it's in court or virtual, some concerns are generated by technology. And then also this bulk access point, which I think is now slowly, thanks to your work and others on this meeting here, is coming more into people's awareness. And I learned a lot about the federal court and immigration refugee proceedings, which I always do from Sean's work. So I really appreciate that as well. I have a few points of discussion. I'll note the time here, and certainly feel free to stop me if I'm going over my time. On the practical obscurity point you talked about, I did really like the critique and the analysis of it. It hasn't been something I've seen too much before. You know, one thing I was thinking about it and reading it, you know, was whether or not, you know, in some ways, the analysis kind of shorts changes what practical obscurity actually does. And I know John mentioned this in his remarks, but talking a little bit about, you know, the fact that if it's a problem for, you know, 50 people to see something because it's online, or 100 people, then it's still a problem for one person in the courtroom to see it. You know, that the sensitivity of the information is there and the practical obscurity won't necessarily be protective. But I thought maybe, you know, in a lot of ways, to me, there is that element of broader dissemination, not necessarily just being more of the same, but also generating, you know, different in kind risks. And some of the paper made me think about that. So for example, many of us probably saw in the news the fact that there's been some criminal charges related to posting witness testimony in criminal trials to social media, for example, you know, and a recognition that, you know, although there can be witness intimidation potentially, you know, within courts, the fact that once you have it at that scale and online, it is a little bit of a different type of situation. And, you know, these are simple examples and none that will be surprising to you. You know, presume I'm in a family law proceeding. It's a lot different to me whether or not every time someone Googles my name, my child custody matter comes to the top of the list versus someone can pull up my name on Canly. And I know you guys are familiar with these types of things. And I also know your proposal doesn't argue for unfettered access. But I'm wondering, you know, to some extent, your argument is let's hit this at the source. So let's think about techniques to reduce the information so it doesn't get out there in the first place. And part of me was wondering, you know, whether or not there's maybe another place for balance here. You know, that whether or not you can retain some points of friction. Are some points of friction ever appropriate? And maybe it's a matter of not thinking about it as friction, but rather as gatekeeping. You know, is the appropriate baseline to think about, well, anybody can anonymously walk into a court and see a proceeding, or do we need to think about having other type of gatekeeping mechanisms? Because it does strike me there's going to be a limit to what you can limit at the source. There's a lot of trade-offs there as well. And thinking about equity and fairness, you know, if someone has counsel, they know to limit information that's presented in a pleading or information to court, are they going to be more protected? Are people then going to think about this trade-off? Well, I'm not going to mention this part of my case because then it's going to go into a court record. It's better that I leave that information out there. When, you know, I teach legal ethics, we always talk about the importance of candor when you're in a legal matter. So therefore, the full kind of aspect of your case can be represented. And then, as you know, is there other trade-offs also potentially in our understanding of what the justice system is doing if too far? So thinking about some of those matters, whether or not, you know, we can move away in terms of thinking about obscuring things or creating friction, and just thinking about, can we have some gatekeeping mechanisms that are appropriate? And I don't necessarily have some, but I would be interested in hearing your thoughts maybe later. I'm probably going to do this thing where I ask you a lot of questions and don't give you space to answer, but we can continue the conversation later. But these are the things that were running through my mind. And thinking about addressing things at the source, another area that kind of raised a lot of questions for me was thinking about anonymization and thinking about the differences. And I think Colin and John have talked to you about this before, but, you know, the party versus witness anonymization, and thinking about whether or not that is necessarily generally a best direction to go. And certainly this context, as you've outlined so well, is so particular, and there may be particular reasons to be concerned. But part of me wonders, you know, does any part of the open court principle, you know, engage with understanding how the justice system treats particular people? You know, knowing exactly who the court is talking about, not merely just a description of, you know, general demographics or biographical details. The easy argument is, of course, we want to know how the justice system is treating powerful people, politicians, things like that. But I wonder if there's also an argument, you know, more generally, you know, are we interested in how the justice system treats particular people? And maybe the answer is no. But I do think there's maybe something there, and how parties are a bit differently situated than witnesses. You know, and so far to date, we've kind of treated it where we've taken certain types of proceedings like young offenders or family law proceedings in some cases, and in this case, immigration proceedings, and kind of exempting them, but wondering, do we need to think a bit more particularly when we're thinking about parties? And there could be also some concerns in this context. You know, finally thinking about also who we give access to this information to. You know, one thing I think I read in your paper was differentiating between commercial and non-commercial uses. And I you know, had some questions and wondered whether or not one might push back on that a little bit. And, you know, we certainly know that the private sector can be capable of some very productive innovations. And assuming those are legal uses of the data consistent with whatever privacy regulations are in place, you know, do we want to think about only privileging public institutions, which, you know, in some cases, you know, university researchers are in a position of privilege, and whether or not we want to have, in some ways, broader access by allowing private sector participants to engage with this as well and breed innovation. Producing technology, so producing legal documents for courts, how some of their legal research is changing. We are certainly seeing much more advanced tools on the market for people who could pay for them. And one of the things we propose in our paper is thinking about potentially, you know, can we have a CAN-LE for legal analytics? Are we at a point where we have to start thinking about providing reliable public tools? Because I think also, you know, one thing you predict in our paper is these tools will become cheaper and cheaper to develop. I think then there's also a concern not only about unequal access, but also access to poor information and how that can impact people's interaction with the justice system and also impact people's confidence in the justice system. So, you know, I think that that's something that we need in Canada to have on our horizons and think about how we're going to address that. Because the technology is there, and if people can pay for it, they'll buy it. And then if people can build it cheaply, they will, and may not have regards to quality. So they'd like to put that on people's radar. My computer's telling me my internet's unstable, so maybe I'll end it there. Hopefully people caught most of that, and maybe I'll put our paper in the chat. So I hope those are types of comments that you find helpful, and I'm happy to talk to you more about those ideas and hear from you about what you think, either later today or at another time. Thanks again for inviting me. I really appreciated it.
Great. Thank you so much, Amy, for those helpful remarks. And I will certainly take you up on the offer to continue to discuss. So next, we're going to hear from Colin Lachance, who is the CEO of Compass Law and the Legal Information Data Institute, LIDI. For years, Colin has lived and breathed access to legal information, and he's developed considerable practical expertise in the area. For 5 years, he worked as the CEO of CAN-LE, and more recently, he founded LIDI with the aim of operating as a steward of public but sensitive court and tribunal decisions and other legal data. So Colin, looking forward to your comments.
Thank you, Sean. Thank you, John, for a wonderful paper. It was great to read, and I appreciate the opportunity to come and chat about it. I'll caution you now, I'm going to be a little bit all over the map here. There were a number of things that caught my attention as I was reviewing it, and each idea led to another, led to another, led to another. So this may not be linear, but hopefully it's reasonably comprehensive. I'm going to pick up on actually, as a starting point, one of the last things that Amy was talking about, and that is as tools advance, maybe it's time to start thinking about reliable public tools in order to begin to engage. And this taps into your points in the paper about information asymmetry. So specifically in the context of immigration and refugee, there's an open RFP right now to develop a predictive tool in the model of a Blue Jay Legal to assess the likelihood of a successful appeal on humanitarian and compassionate grounds. Now, this RFP had floated around over the course of about 3 years with the federal government as a discussion paper and as a notice of proposed procurement, as a request for information, and then finally an RFP. And in the end, there were about 7 companies that bid on it. And in the end, among the limitations in the RFP was it could only be based, the data could only be based on publicly available decisions. And they couldn't reference judges as one of the reasons why something could or could not result in a successful appeal on humanitarian and compassionate grounds. So this left a lot of the potential bidders, our commercial side included, looking at it and saying, this is kind of silly. But it's at least a step forward into the idea that if as you pointed out in the paper, if the federal government is in a position to know more and more and more relative to the people who are either self-represented or even if they're professionally represented, at least there's some contemplation towards a tool being made available to assist them, albeit in a narrow way. And if everything works out, you should see it sometime around 2024. So on the public advancement of legal technology under the status quo, that's where we're at. And so when you bring this back into the conversation about, well, how do we improve that? I think that's where we start diving into the meat of your recommendations about maybe you don't want to go all the way to where the media lawyers are, although I'm more sympathetic to that. But you do have to start making the data more available. While finding a way to protect the legitimate privacy interests of the parties. And so one example of that, and again, in the paper, looking for a way to sort of thread the needle between academic interests and public interests versus commercial. I mean, right now, and actually dating back to 1997, there's a statutory instrument, federal statutory instrument called the Reproduction of Federal Law Order that basically says, if it has to do with federal legislation or federal courts or tribunals, you're allowed to reproduce without permission or royalty, the outputs of that. Now that's just sort of the nice thing that sits out there. In the province of Ontario, for example, there's a similar policy, but practically it's not enforced or enabled in any meaningful way by either governments or courts. It just represents almost like an acceptable, almost like an acceptable infringement on copyright. And so what we're lacking is, I think, a sufficient definition of open courts in a way that could actually bring us to the point of feeling comfortable with a lot of commercial development or academic advancements and understanding of this material. In the practical obscurity component weighs in here, not at the micro level, but at the macro level. So if you have a broad right to work with some of the public data, but you don't have any ability to access it or any necessary means to engage with it, do you really have that right? And so this is one of the things that I'm always uncomfortable with in any of these discussions, because I'm not fully about let's put it in everybody's hands, but I'm pretty close to that idea. There has to be some way to put it in everybody's hands. And so, as you mentioned, I set up the Legal Innovation Data Institute to see how close we could get there without the courts slapping our hands. Now, the reason I was able to do that is because Compass Law assumed the position when it acquired a company called Maritime Law Book, who was a legal publisher dating back to 1969. So Maritime Law Book, along with Lexis, Westlaw, Canley, and in Quebec, Socige, has a relationship with the courts to directly receive cases for purposes of publication. So commercially accepted as a steward. But a lot of those arrangements across publishers are based on inertia and not detailed or consistent principles across courts. So even the more recent Canadian Judicial Council guidance piece, Canadian Judicial Committee guidance piece on bulk access this represents points for further discussion, but not an example of something that we're going to see broadly. So what I tried to do with Liddy was to say, well, with my best assessment of what certain courts expect as it relates to use of this data, how far can we go, and what can we do to push that? And so we set up all kinds of little safeguards and provisions to ensure that any group, whether academic or commercial, that began to work with data that we made available to them, that the courts have made available to us, wouldn't cross lines from the courts. Because as this is happening, courts are constantly changing decisions. The decision issued yesterday might be withdrawn today for publication. A decision issued 25 years ago, we might get a note from the court saying, we now want to anonymize these people. Like, I'm not making this up. This happens like weekly to publishers. So we had to find ways to manage it. So when any court engages in sort of a broad discussion around how do we make this information more available, my antenna always goes up, because I know at a practical level, they still see themselves as the stewards of it, and have as long a reach as is necessary to change the terms in which the material was previously made available. So consequently, my expectation is they're always going to find some way to limit how this information is made available and for what purpose. So where does that leave us if we actually want to address information asymmetry, and if we want to improve understanding, and if we want to enable access to more advanced tools? I think it brings us around to anonymization, and as at least the least worst way of addressing this. So one of the first things we did with legal innovation data.
Just to say, just one more minute left here.
Sure, this is my final point. One of the first things we did with Legal Innovation Data Institute was partner with a natural language processing company called Private AI, who focuses on privacy protecting artificial intelligence. And so we've gone through several rounds of tagging and redacting to try and train systems to identify and differentiate between public participants in a judicial process and private participants. So a private participant could be the neighbor who's referenced, the witness, as well as the party. Public participants could be the border services officer, the social worker, the lawyer, the judge. And I can tell you that while we haven't completed the process, every indication that we have is that this will be a successful method of a very high degree of accuracy of differentiating between private and public. So I think if you're gonna put your chips down on something, for me personally, I would put it on anonymization and then figure out the time and place to do it that's most effective to address the other objectives.
Thank you so much, Colin, for that, and for other discussions that we've had on similar topics. I've learned a lot from what you guys are doing at Lady. Okay, so our next speaker is Anne Coe. Anne is a director and senior legal counsel at Taranet, which is the exclusive provider of Ontario's online property search and registration, and the owner and operator of Manitoba's property registry. Like Colin, Anne's day-to-day work involves legal information, and Anne has also grappled with these issues in other roles, including as legal counsel for CBC, and as the author of an LLM thesis that focused on access to court record policies across Canada, including in the territories. A thesis that I had the opportunity to read and that I commend to all of you. So Anne, over to you.
Thank you, Sean, and just want to say thank you for the invitation of appearing on this panel. And thank you, Sean and John, for reading my thesis. I was pleased as punch when I heard that someone that wasn't related to me was actually reviewing it. So thank you. So as Sean had mentioned, I currently work at Taranet. We're a Canadian company, and we offer digital solutions with regard to the land registry systems in Ontario and Manitoba, as well as a number of data-driven products. This was an exceptional paper. I found it to be, after reading it, I had a lot of sort of question marks in the air. I wanted to delve more into refugee and immigration issues. So I commend you both on this work. And so, as mentioned, I did do an LLM thesis back in 2016, and I focused on various access to court record policies within the common law jurisdictions of Canada. And I argued in favor of uniform access to court record policies to be adopted by all common law jurisdictions prior to any kind of, wholesale digitization, while still safeguarding the unnecessary access and disclosure of personal information within a court file, I think considered to be non-essential to the facts of the story, as would want to be disclosed by the media to the public. Research for this actually was sort of born out of my work that I did during my time as legal counsel with the CBC. I was working quite extensively with the Nunavut Court of Justice and a chief justice over there. So I really delved into the challenges that Nunavut had as a region. And they were challenges that were unlike any other region. So in comparison to, I would say, provinces that, could be classified as have versus have not, resources were a big thing, but also the proximity of, I would say, communities of people knowing each other and risks associated with disclosure of details that could compromise or in fact put some litigants in danger, which I thought was an added issue that some jurisdictions simply didn't have to deal with. So I think it was within the paper some welcoming news in terms of the federal court taking that initiative to innovate and evolve into a more digital platform for increased accessibility. Of course, that's not without its challenges. I did find interesting the presentation of the CBA's perspective in concert with the CMLA's perspective. I did, for a period of time, was a part of the CMLA, more commonly, I think, within that group known as ad idem. And, I think it's safe to say that both of those perspectives are on opposite ends of the spectrum. So I do find the CBA's position in agreement with Sean and John to be overly restrictive. But I do believe that their highlighting of data security is of paramount importance. I think we're dealing with a lot of risks and evolving threats that were unheard of months ago. But you have something like ransomware that is run of the mill now, with cyber insurance sort of costs going through the roof. So I think malware is a significant threat. A couple of things that I wanted to highlight from the paper that I found to be quite interesting was that importance to dismiss practical obscurity as a meaningful approach. I think I'm in agreement wholesale with Amy on her comments in that respect, as well as the importance of the treatment of technology as agnostic. So with respect to that practical obscurity element, I was, as I was reading through this, I was somewhat surprised about how this continued reliance on practical obscurity as some kind of legitimate or effective doctrine. And then I did actually go back, revisit my thesis from 2016 and realized I had a quite an extensive argument against practical obscurity as well. So surprising to see that, it's still something that's highlighted. I did also find amusing the CBA's recommendation that the court should keep some documents obscure from certain groups of people deemed less trustworthy, and those were identified as lawyers in the media, two groups that adhere to a type of code of conduct. And I can say with direct firsthand knowledge that trustworthy would probably be the last descriptor I would attach to some groups of people that populate those two groups. So I thought that was quite interesting. And I think certainly, with the proliferation of technology, access with our smartphones, blogs, social media, et cetera, it goes without saying that anyone with a phone is a publisher and a journalist. So I do think that we need some proactive recognition in terms of like certain fields and types of information that I would argue should be preemptively reserved from general access to the file. So if you had other jurisdictions, say maybe Saskatchewan and Nunavut, who had sort of a person at the helm known as a court records officer who would go through and pull out what they believe to be sensitive types of information. I think, with advances in technology, and I certainly wouldn't advocate for, a bot to be at the helm of any of this necessarily, but I do think that, key parts of information deemed as sensitive, particularly within the context of refugee and immigration hearings, should be reserved, from general access straight from the get-go. And I would be interested, Sean and John, in your take in terms of, types of key general elements of private information that should preemptively be redacted from a court file before it becomes publicly accessible, if that's at all something that had come to mind. I'm not sure, and again, this is an agreement with Amy. On page 23, there was mention of full anonymization of party and witness names. I presumably the take from the CMLA would be to keep everything accessible in the file. I do think that there's a type of middle ground that could be achieved, again, in terms of preemptively redacting certain fields of information considered to be personal or secondary to the actual court case. I think from the CMLA's perspective, not to speak for them, but I think there's a safe bet or assumption to make that anything is essential to the telling of the story or relaying that information to the public for, of course, increased transparency into the judicial system and, having that increased open access. But again, I think, like there was in Nunavut of special considerations intrinsic, to that jurisdiction. Same thing goes for immigration refugee trials. There's information that arguably may be central to the actual case itself, but in any respect, is something that would be considered highly sensitive if it were disclosed, I think, on a broader basis. A lot of information here, so I'll try to speak quickly, but I just wanted to touch very quickly on the issue.
Just to say, you've got 1 minute left.
Sure. The issue of technology playing a neutral tool here, and just echoing sentiment from John about how technology shouldn't be purveyed as inherently privacy invading. So I think, with the right people at the helm, with the right intentions, and you can insert your benevolent dictator philosophy argument here. But I think that, in the right hands, technology should be used so that there is that, widespread access available. I think to close, what I would have wanted to look a little bit more into, and Sean and John, this is maybe some food for thought. I did find it pretty fascinating about the key information and government having access to that, obviously being involved in every file, and the information asymmetries. What could be done in terms of trying to resolve this issue, whether it be, assembling of, those lawyers at the bar who are involved in this type of work, or, what possible solutions could be, outlined in terms of, dealing with these information asymmetries head on. But in any event, I commend you both for your research and work, and thank you again for the invitation to participate.
Thank you so much, Anne. And so our next speaker is Kat Germani. She's legal counsel with CBC Radio-Canada. Like both Colin and Anne, Kat's day job involves legal information. For about 6 years, she has helped CBC journalists navigate access to court records, as well as many other issues around reporting legal information. So Kat.
Hi, everyone. I hope you can hear me well. I only have audio today, unfortunately. I'm really grateful to have been invited. I just think this is such an important and interesting issue, and I was really grateful to read the paper. I'm a media lawyer, so I speak from that perspective, but I don't speak on behalf of CBC. I found that in the paper there were some really compelling points, like such as the need for transparency, highlighting the lack of access to court decisions and records. One thing I found really interesting was on fees or minimal fees payable for digital access, because that's become something that we see in practice is more and more of an issue in the work that I do with journalists. And I can point you to a recent decision that we dealt with as a media consortium at the Toronto Police Services Board that went to the divisional court in Gautier that might be helpful on that. The practical obscurity points and the problems with the federal court access system generally, I think I would agree with. So I'll just kind of focus my comments on one thing, which I think is pretty foundational to the paper, but that I would just point out. I think that there are some, in my opinion, issues around the legal framework, simply because the legal basis for de-identification, in my opinion, isn't quite made out. And the reason why I push back on this is because the way I look at the issue is that the state is required to provide access to courts, to court records, to court exhibits. That's all part of that presumption of open courts. And we see that arising through case law. And I know that you pointed that out in the paper, that it's primarily a body of case law that guides us in that realm. But when the state hinders access to courts, that's a constitutional violation. I think that's really key. And that's because open court principles folded into our Section 2B rights. And so absent legislative intervention, like in Quebec with family courts, this is always the case. So in my opinion, the proposal regarding de-identification doesn't fit with the law. It reverses the onus, which is contrary to Supreme Court guidance going back to Dagenet-Mentuck, which first applied the Oakes type analysis. And that's because de-identification is a redaction and a sealing of information that's an exceptional measure. So what you're suggesting in the paper is that it's, rather than requiring the person who wishes to ask the court to exercise its discretionary power and undertake a legal test with the notice given to the public and media, and then perform an analysis in a public forum or perhaps in a closed forum if there's need to do so, and then come to a decision on that in a contextual basis, it would be done preemptively. There's no ability to undertake or consent to such an order without that judicial analysis, at least in the state of the law as it is now. So what I think is that perhaps the paper would benefit from pointing out the legal framework at the very least for such discretionary orders. So, you did reference at one point the Sherman decision, which is relatively new. And what's interesting about Sherman is that it highlights that there's a very narrow dimension of privacy that's now of relevance to a court in ascertaining whether or not there should be any portion of a court record that should be sealed or removed from public view through a publication ban. And it's amounting to human dignity. So the way that the court talks about that is that every person has a stake in court openness, but not in the privacy of an individual, only in the aspect of their privacy that's tied to dignity. So the court does define what that is. It says that it's information that's so sensitive that its dissemination can be an affront to dignity that the public would not tolerate. And there are examples, and some of those cover, Sean, what you were giving as examples that could be very pertinent in the refugee and immigration context. So disclosure of sexual orientation, HIV status, history of substance abuse and criminality, stigmatized medical conditions, stigmatized work, subjection to sexual assault or harassment. So, fundamentally, I think what I would point to and say is that it must be contextual analysis. There cannot be any kind of preemptive closing. I think that there's a sensitivity to privacy that we all have, but that must be balanced with the idea that open court is paramount. And I think that's really the crux of what I wanted to say, which perhaps is a bit short. I do have a few other comments. I found the paper really interesting and, like I said, quite compelling. So Sean and John, I'd be happy to talk to you a little bit more about this. And if you'd like, I can talk to you about how some of these things may impact people like my clients. But thank you. Thank you again for inviting me.
Great. Well, thank you so much, Kat. And I'm sure John and I will take you up on the generous offer to engage further on these points, including on the question of the legal authority of courts to pursue de-identification practices. There's an interesting question there, I think, about what you do in a context where the court's not actually obliged to publish anything. I think it's a complicated question, but I look forward to engaging further. Our final speaker today is David Lepofsky, who's the chair of the Access for Ontarians with Disability Act Alliance. And before taking on that role, many of David's professional and academic interests focused on several of the issues that we're talking about today. So for years, David's career involved questions related to freedom of expression, including access to courtrooms and court records by the media, but also by individuals who couldn't easily access either because of a lack of equitable access. So David, when we were putting together this paper, much of your work in the area was really a touchstone. So we're grateful that you were able to join us today and share some comments. So over to you.
Hi, can you hear me okay?
Yeah, we can hear you. Thanks.
Okay, great. Well, thanks for including me. And this is a great discussion. And a particular shout out to my old friend, Amy Salazan, who is one of the smartest people you'll ever meet and a fabulous legal thinker. If you hear buses and subway stops being announced on TTC, that's because of cases I brought in. She would juniored to help me present my case about buses and streetcars. And I couldn't have done it without her. She's fantastic. I approach this issue actually from two perspectives, the open courts thing and access to courts. One, I've always had a strong academic interest in freedom of expression. I teach a course on freedom of expression at U of T Faculty of Law, and I have for, this is my 31st year, and I've litigated and published in the area. And I also deal with, my disability advocacy deals with accessibility, and that includes access to courts in the sense of, can people with disabilities actually get there and get in there and get around there and fully participate? So two different headings and sometimes two different perspectives. The latter is an advocate, the former now in more of an academic role exclusively. And I'm going to give you just some high-level comments that will maybe trouble or shake you up a bit, and that's okay, because that's what we should do. Number one, all of the discussions now proceed on the basis that there is a Section 2B constitutional right under freedom of expression, freedom of press, to access to court proceedings, to attend them in person, and to access to court records. Now, I'm fully agree that court proceedings, court records should be open. And I'm a passionate believer in the open justice principle. I wrote a book called Open Justice. So kind of go figure. But, and my writings on it have been quoted in the past, including by the Supreme Court of Canada, when the Supreme Court concluded that Section 2B includes a right not only to communicate to others information about what goes on in court, but actually to go in and watch proceedings. Now, here's what may shake you up, and it may affect your relying on my writing. I don't agree with me. I was wrong, and I think the courts are wrong. And it's bizarre to have written it, and then the Supreme Court agrees with it. Then I turn around and go, but I was wrong, so are they. But I actually don't think a proper interpretation of Section 2B of the Charter leads to an accurate conclusion that there's a right to attend court. I think what the courts did, and in my earliest years, what I did is say, open justice is good, open justice is important, open justice is essential, all of which is true. So it's got to be in the Charter there somewhere. Well, we can't hitch it on Section 11D, because that's the right to a fair and public hearing is there assigned to an accused person, not anybody else. And so, well, the media asks for the right to attend court, so I guess it's part of the media or something. So let's go to Section 2B. And I think a principled analysis, and we don't have time here to debate this, but I'm just telling you as a starting point that I start there. And the second thing I'll tell you, and what I'm actually going to focus more on, is that under Section 1, even if it is a Section 2B right, that individual privacy needs to be given, treated as a sufficiently compelling objective to warrant some limits on that right. And we need to take a principled look at how to do that. Now, I got to actually argue that point and got at least a plurality or a concurrence in the Supreme Court of Canada to that effect in a case called Edmonton Journal versus Attorney General of Alberta. This is back in the late 80s or early 1990, where there was an Alberta law that closed court proceedings and family proceedings most, if not all of the time. And we didn't intervene. I was then counsel for the AG for Ontario. We didn't intervene to defend the law itself, but to talk about some general principles. And we argued that privacy of the individual is a Section 1 defense that needs to be recognized. Now, my friends and colleagues from the media over the years that I argued cases against the media will take strong and principled exception to that. And both I in my counsel role, and now I in my independent just telling you what I think role, don't agree. I don't think privacy is an all or nothing, that once you're involved in court proceedings, all your privacy is gone because some of it is gone, and so on. I think it's oxymoronic that our criminal justice system, for people who are subject to open trials, rests on the principle of the public knowing when someone is convicted, because that is an important part of deterrence, denunciation, general deterrence, and individual deterrence. On the other hand, if you try to find out what someone's criminal record is, which is public information, it's not private information, they're convicted in open court, it is extremely hard to find out unless you are involved in the administration of justice or have an authorized reason to do a criminal record search, which actually undermines the very deterrence principle that overlays the system, and is one in which there is arguably no privacy interest. I will tell you that just a couple of other things, because I know our time is short. Once we get into privacy, we need to evaluate it not in the John Stuart Mill view of the world from the 1800s, when we didn't have mass communication of any sort, and when newspapers could reach a much smaller audience over a much longer period, or taking a much longer period of time. But we have to talk about what privacy and information privacy means in the 21st century, where there's the instantaneous mass distribution capacity of not only the conventional media, but social media and the World Wide Web. And I think it's qualitatively different and needs a closer look. That became the most apparent when I was involved in litigating to defend the government's, against the CBC, the government of Ontario's restrictions on cameras in the courtroom. Treating a courtroom as just an open place, and therefore, once you walk in there, you're also subject to being video recorded and simultaneously broadcast all over the place, is an attempt, or in my view, and I'm sure my colleague on this panel from the CBC will take a passionate and principled objection to this, but treating them as simply one follows because from the other, as night follows day, I think is inaccurate and fails to regard the privacy intrusions that are distinctive when you use cameras, as opposed to when you talk to, when you just have somebody testifying in an open court and members of the public can come in and watch and tell others what goes on. My last point, and closest to the specific focus you're dealing with here, Sean, is this. The whole concept of public record openness predates the Charter, and of course is traceable to the Supreme Court of Canada's 1981 decision in Attorney General Nova Scotia, Scotia versus Lyndon McIntyre, a then well-known CBC journalist. There, the openness principle was espoused not as a charter thing because the charter hadn't yet been approved, but as a common law principle, and I no problem with it being a common law principle at all, contrary written that that should be where this is found. But the Supreme Court in that case said two things that were actually contradictory on the point that, Sean, that you're focusing on and this paper focus on. On the one hand, it said that the sensitivities of the individual are not a justification for restricting open justice. They are access to records. And on the other hand, it said closing or restricting access to protect the rights of the innocent is a justification. Well, where do the sensitivity of the individual end and the rights of the innocent begin, or vice versa? In other words, one could, I have trouble with the term sensitivity of the individual because it can be used compendiously to include the city council member who's convicted of stealing public money and doesn't want his or her sentencing to be conducted in public, which is personal sensitivity, and we'd all say tough bananas, bud. And on the other hand, the quote sensitivity of a witness with a mental health condition or an intellectual disability that happen to have the effect of literally precluding them from being able in the circumstances to testify at all if they have to do it in public. And one is a quote sensitivity of the individual. The very term sensitivity of the individual kind of works on the premise that we should all be tough enough to just handle it. And frankly, some aren't, and it can be a barrier to justice. And one could equally say sensitivity of the individual as applied to the rights of the innocent are the same thing. The police did a search warrant on your house. Turned out they didn't find anything. Well, don't be so sensitive. It just means they didn't find anything. We need a more principled way of dividing this. And I think that both of those conflicting terms are both focusing on what is in effect could be addressed under the principle of privacy. So we need to take a look at when does openness end and when does privacy begin? And that is a very nuanced thing, not just something that can be decided categorically. So with that very high-level discussion that entirely evades the pinpoint questions that you folks are commendably wrestling with, I'm going to kick it back to Sean.
Thank you so much, David. I've certainly had the experience of disagreeing with myself quite frequently. I think it being fairly new for you is just an indicator that you're often quite persuasive, even to yourself, even if maybe there are occasional exceptions. But thank you very much for your comments, and thanks to all of the discussants for offering their views. Michelle, could you end the recording now?